Welcome everyone to our August Caregiver Support webinar. Today, our topics that we're going to be discussing is types of guardianships and kin gap. Let's go over the logistics. The webinar is being recorded and will be available at CDSS Caregiver Supports webinars and CAC webinars sites. Closed captioning is available. Look for the CC icon in the bottom left corner of your screen in case you have a hard time hearing. Participants will not have the ability to speak. Please submit questions to the Q&A section of the toolbar. The icon with 3 dots should give you this option. If you would like a certificate of attendance, please email your request to info@caregivers.org. Our agenda today, I will be going over the different types of guardianships that we have in California and how they relate to resource families. Then, right after me, we'll actually have Charm Lee discussing kin gap, and then the caregiver perspective will be done with Jennifer Rexroad and Brenda Checklinis. And then we will have times for questions and answers with our staff. We will try and answer all questions that are related to today's topics. If you have questions outside of today's topics, then please reach out to the unit that are the subject matter experts in that topic or your local county office.
Salima, it looks like you may be muted.
I apologize. What is the last thing you heard?
We haven't heard anything about this slide yet, so you can
Okay.
get started there.
Thank you. So when we're discussing legal guardianship in California, what that is a court order that says someone who is not the child's parent is in charge of taking care of the child. Legal guardians have many of the same rights and responsibility as parents. The 2 types of guardianships in California most of them are held in probate court. However, if CPS, Child Protective Services, is involved in the case, or the child is a dependent of the juvenile court, the guardianship case will be probably in juvenile court. Guardianship is most frequently, go back to the first slide, I'm sorry. Guardianship is most frequently used by relative caregivers who wish to provide a permanent home for the child and maintain relationships with extended family members. So, unlike adoption requirements, caregivers can assume legal guardianship of a child in out-of-home care without termination of parental rights. And this may look like a non-related legal guardian or a relative guardian, what we know of as kinship guardian. If you want to try to obtain guardianship through probate court, a person who wants to be appointed guardian of a child must file a petition with the probate court. The child's parent or the child, if at least 12 years old, can also file the petition. However, in juvenile court, a case is started by another entity, and you will be instructed by a social worker or probation officer, on what is court ordered and must be done in this type of situation. Next slide. So these are the different type of caregivers that you may hear about in California. And so we have resource families, what was formerly known as foster parents, and they provide temporary out-of-home care for foster children while arrangements are made to return the children to birth families. Foster parents do not replace the child's birth family, but resource families do assume many of the roles of the child's parents and must provide for the child's needs beyond food and shelter while the child is in their home. The relative caregiver or kinship care provider is requires that when a child is removed from the home, the relatives must be located, contacted, and told about the child's removal within the first 30 days of removal. So the law known as California AB 938 and federal law PL 110-351 allows for consideration of relatives as a placement resource for the child during this difficult time. According to Welfare and Institutions Code section 361.3, relative means an adult who is related to the child by blood, adoption, or affinity within the words great, 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 or grand, or the spouse of any of these persons, even if the marriage was terminated by death or dissolution. However, only the following relatives shall be given preferential consideration for the placement of a child. And that would be an adult who is the grandparent, aunt, uncle, or sibling. The expectations of a relative who accepts placement of a child in their home are the same as those for licensed resource families. Then we have the non-related extended family member. And we look at that also as part of the fictive kin. And so the law defines the non-related extended family member as an adult who has an established familial or mentoring relationship with the child, such as a godparent, a teacher, or a neighbor. The county welfare department shall verify the existence of a relationship through interviews with the parent and child or with one or more third parties. Now, the third parties can include relatives of the child, teachers, medical professionals, clergy, neighbors, and family friends. We also have the concurrent parent, and they are resource family parents. They are the same as a resource family and a prospective adoptive family. So concurrent caregivers, they are doing the resource family guidelines, but they also are the prospective adoptive parents at the same time. And that can be with relatives or non-relatives. And it's just the person who provides care for the child while reunification services are provided to the child and his or her bio family, and concurrent caregivers actively support reunification efforts, but you're also willing to provide a permanent home when it is not possible for the child to reunify with their parents. If reunification with the birth family does not occur, the concurrent caregivers may then pursue adoption. The adoptive parent, these families provide a permanent, safe, stable, and loving home for a child when it has been determined that the child cannot safely be returned to their birth parents. And adoptive parents can be relatives or non-relative families. And we just discussed legal guardianship in the previous slide. Next slide, please. In California, we also have other options outside of guardianship. And so a guardianship is not always needed. There are simpler, less formal options that'll give you the legal ability to care for someone else's child. You might also be able to care for some of the child's needs if you can't get a hold of the parents. You don't have to go to court for these options, but they're not right for every situation. So, one of the first ones is having a caregiver's authorization affidavit on file. So, if the child lives with you in California, you can sign the caregiver's authorization affidavit, and the parent does not need to sign this form at all, but they can cancel it at any time. And what this form does, it allows you to enroll the child in school and consent to medical care related to school only. So, for example, you can't consent to vaccinations or physical exams. If you're the child's relative, you can also make medical care decisions outside of the school context, but someone not related to the child can only consent to medical care related to the school. And then the caregiver authorization affidavit form lists who qualifies as a child's relative. This is a form that must be signed annually, and it is not valid if the child no longer lives with you. You must let the school and healthcare providers know if the child moved out of your home. The second one I want to tell you about is the written child care agreement. So parents can sign a written agreement. Technically, it's better known as power of attorney. That's how we say it. And it gives you the authority to care for their child if they know they will not be able to take care of the child temporarily. So, for example, if the parents will be going out of town for work, or if they're in jail or getting medical treatment, the parents may want you to sign the form too, just to make sure you accept the duty to care for the children. You will not have the right to make any decisions that is not listed in that form. So, for example, say the parents might want to give you the right to make decisions about the child's medical care and education, but not the right to change the child's residence or consent to the child getting married. Um, Discussing safety concerns. If you're worried about the child's safety, if the parent cancels your rights, these all of the two options that I just spoke to you about, the parents can cancel them at any time, and then you will have no rights whatsoever. So if you were looking to get something more permanent or court ordered, um, that's when you want to look into guardianships. But parents may ask a judge to end guardianship, but that does not mean that it will be granted. Another reason why you would want to not go this route and look into guardianship is if you want to add the child to your health insurance, because most insurance companies will not add someone else's child to your insurance policy unless there is a court order like guardianship. So make sure you have the child's health insurance information. And because of legalities and nuances, you might decide it's just easier to have a court order that has that others have to follow. So in California, schools and medical facilities, they are required to accept by law the caregiver's authorization affidavit, but sometimes staff aren't familiar with them and they may be hesitant to accept them. So you might have to educate the staff about it. Or some people might find it just easier, like I said, to go the official court route so there's no misunderstandings at all. Next slide, please. So I'm going to discuss the rights and duties of different types of caregivers. Go ahead and switch your slide. And what we're going to be looking at and discussing is a comparison of what resource families can and must do against what guardianship families can and must do. So when we are talking about fundamental responsibilities and general duties, if you're a resource family, you'll work with the child welfare agency social workers to provide care, supervision, and housing for the child. And you'll receive funding and in the foster care form for the needs of the child. You will also work with a social worker to make sure the child receives available resources and services. And you can attend hearings and give information to the court. You must be invited to attend the CFT, but you do not have to attend the CFT. It is suggested unless there is other circumstances where the person with the rights do not want you to attend. And being a resource family is viewed as a temporary situation. In guardianship, most guardianships, they have the same general rights and duties towards the child as a parent. They are responsible for providing all of the needs of the child, including appropriate services. They must provide for the safety and protection, physical and emotional growth of the child. And they may have to complete classes like parenting classes or attend counseling with a child so they can have a better transitioning into the family. And it is viewed as a permanent guardian situation. Next slide. Thank you. When you're looking at custody and visitation, the resource family will have physical custody of the child, but the parents will still retain their legal custody. The resource family, the resource parent must make sure that the child takes part in visits and phone calls with parents and others that are authorized by the social worker or court ordered. And the resource family cannot directly ask the court to terminate parental rights and adopt the child. However, they can inform the social worker that they would like to be considered as an adoptive home for the child, which would then make you be one of the concurrent families that I spoke about earlier. With guardianship, they have legal and physical custody of the child. The parents still hold their rights. They're suspended, but not terminated. So as it won't be terminated as long as the guardianship remains in effect. The guardian can decide who visits the child unless it's otherwise ordered by the court that is certain people that they cannot have contact with. And the guardian can also petition the court directly to have the parent's rights terminated so that they may adopt the child after they have the custody of this child for a specific time frame. Next slide. When it comes to residents, the resource families have to abide by what the county social worker, the child's tribe, and or the court order decides on who the child will live with. So that can be something that is changed throughout the time of you getting this child. And it can be changed with a court order or the social worker or tribal council. They have the authority to change these things. When we're dealing with guardianship, they can decide where the child lives. Usually it is with them unless that is not in the best interest of the child. And they do have to report an address change in a timely manner to the courts and all parties that are involved. And they must get permission to move outside of California, but they do not have to have permission to move into another city within California, as long as they give proper notice. So when we're dealing with healthcare, resource families will still partner with the social worker because the social worker arranges care and treatment, but the resource parent will be responsible for scheduling and transporting the youth to these appointments. The parents keep healthcare decision rights, except for in the case of an emergency or if there is a court order stating that they do not have these rights. With guardianship, that parent has the authority to consent to the child's medical treatment in most cases, not all cases. And that would be something like if the youth is 14, excuse me, if the youth is 14 and up, then they have to give consideration and consent to what the youth wants. And must give, the court must sign the document, the child and the parent must have consent, unless there is a court order that just authorizes the surgery or an emergency exists. The parent cannot place a child in a mental health treatment facility against their wishes. A separate legal process is required for that. However, the guardian must obtain any counseling or other necessary mental health services needed by the child. And the parent cannot go against certain state laws that allow children to consent to certain types of treatment. And this treatment would include outpatient mental health treatment, medical care related to pregnancy or sexually transmitted diseases, and drug or alcohol treatment without the consent of a parent or guardian. Next slide. For education, resource families, the parents hold the educational and developmental services decision rights unless the courts order them to someone else or order them to the resource family. They cannot attend an IEP unless invited by the person holding educational rights. The resource parent is responsible for making sure that the child attends school and works with the school district and service providers to ensure that the supports in the IEP are given and followed. With guardianship, the guardian holds the child's educational and developmental services decision-making rights, unless the court appoints those to someone else. The guardian must advocate for the child with the school district to make sure the appropriate arrangements and services are given, especially if there is special education needs. Next slide. With consent to changes in the child's status, a resource family cannot consent to the child's marriage, underage, enlisting in the military, or getting a driver's license. However, the juvenile court can consent and make an order. With guardianship, a guardian and the court must give permission for the child to get married prior to being 18. However, the guardian can consent to this child enlisting in the military, obtaining a license, and getting them a passport. Next slide. When there's financial obligations, the resource family receives foster care funds to pay for the child needs. However, in guardianship, the guardian is responsible for the day-to-day financial support. So although the parents are still obligated to support the child, they can try to obtain legal action by getting an agency or a court to order child support from the parent. With guardianship, they can receive child support, AFDC, FC benefits, Social Security benefits, VA benefits, Indian child welfare benefits, and support from other public or private sources. With legal liability, the resource family, they are immune from liability in a civil action to recover damages for injury, death, or loss to person or property caused by the act of a child placed in their home, except in limited circumstances. Okay. And then you can read more into that, which will be one of the resources we have that we're going to give out to everyone in the WIC code section 362.06. With guardianship, though, a guardian is just like a parent, is they're liable for the harm and damage caused by the willful misconduct of their child. So there is usually a limit on how much a guardian may be required to pay. And there are special rules concerning harm caused by the use of a firearm. If you believe any of this information that you hear or see in this webinar might pertain to you, please contact the county social worker or probation officer on your case. There are certain laws, certain state laws involved, while also considering certain information and allowances that are county specific. Every case is unique in its own circumstances. So make sure you research and follow up with the necessary people for your specific circumstances. I see we've been getting questions in the chat. We will definitely be discussing those in the question and answer section. Right now, I'm going to go ahead and hand this over to Charm Lee. She is going to be discussing kinship and all things related to kin gap. Welcome, Charm.
Thank you, Salima. I'm going to be going over the general provisions of the Kinship Guardianship Assistance Payment Program, which most of you probably know as KinGAP. This is a funding program for caregivers once they are appointed guardian through the juvenile court. So this funding is not available for probate guardianships, and guardians cannot independently apply for this funding. Next slide. Once enrolled in KinGAP, a youth may continue to receive KinGAP payments after their 18th birthday up to age 19. Oh, can you go back to that prior slide, please? I didn't go over the eligibility requirements. So in order to be eligible for KinGAP, the child must be a dependent or ward of the juvenile court, which means they would be under either child welfare services or the probation department. And the child or youth needs to be living with an approved relative for 6 consecutive months after the home is approved through the resource family approval process. There's a guardianship agreement that must be signed prior to the guardianship order, and the dependency or wardship must be dismissed in juvenile court. Next slide. So once enrolled in KinGAP, the child or youth can receive KinGAP payments following their 18th birthday until age 19 under what we call the high school completion rule. If the payments began before the youth's 16th birthday and the youth is attending high school or an equivalent program or training school, they would be able to receive payments until they're 19 years old. Next slide. So eligibility for extended KinGAP, the criteria is listed on this slide. So extended KinGAP is KinGAP until the youth is age 21. In order to qualify for extended KinGAP, the youth has to have been at least 16 years old before the KinGAP payments began. And they have to be completing a secondary education or a program leading to an equivalent credential. They have to be participating in a program designed to promote or remove barriers to employment. They have to be enrolled in an institution that provides post-secondary or vocational education. The youth is employed for at least 80 hours per month. If the youth can't do any of these, then they have to have a medical condition that says that they are incapable of doing any of these activities. So those are the criteria for eligibility for extended KinGAP. Next slide. If the youth is under 21 years of age and they have a physical or mental disability, they would be able to continue receiving extended KingGap benefits until the age of 21, regardless of the age that the legal guardianship was established. So if you recall from the prior slide, we said that in order to be eligible for extended KingGap up to age 21, you had to have entered into the KingGap agreement after age 16. However, if you have a documented disability, you are eligible for KingGap benefits up until 21 years old, regardless of the age that the guardianship was established. Next slide. If a child is a member of a tribe or a citizen of a tribe that's federally recognized in California, we have 109 federally recognized tribes, then the tribe can choose to approve their own homes. So a tribally approved home is a home that is approved by an Indian child's tribe or a tribal organization designated by that tribe. And tribally approved homes are not required to complete the resource family approval process just for the purpose of entering into the KingGap program under a guardianship established in juvenile court. And if in the middle, you'll see WIC sections 11362 and 113191. Those are the KingGap statutes for state and federal KingGap. This tribally approved homes provision was added by AB 120 and effective July 10th of this year. This is in our KingGap statutes. Next slide. So for federal KingGap, the child has to be eligible for Title IV-E foster care payments while under the jurisdiction of the juvenile court or voluntary placement agreement. Under federal KingGap, if a youth or a child has a sibling that is 4E eligible, then the siblings are also eligible for federal funding as well. In California, the definition of a relative includes individuals not related to the child, and we call those individuals fictive kin. Next slide. And these 4 bullet points have been in statute under the federal KingGap statutes. So an adult who's related to the child, so that's the regular definition of relative that you're familiar with. An adult who meets the definition of a non-relative extended family member, you probably know those individuals as NRFMs. And then an adult who's either a member of the Indian tribe or an Indian custodian as defined in the United States Code. And an adult who is a current foster parent of a child under the court's jurisdiction. They have to have a significant and family-like relationship with the child. Next slide. And AB 120, again, the same bill that I just mentioned, effective July 10th, an adult who meets the definition of an extended family member in the case of an Indian child was also added to our federal KingGap statute. So prior to this bill, we only had relatives, NRFMs, and then Indian custodians, etc. Now an adult who meets the definition of an extended family member, and that's defined by each tribe. So that would be in our United States Code under the Federal Child Welfare Act, and that is in our California statutes now. Next slide. So subsequent guardians, these are guardians who are not the initial guardians that were appointed when the child or youth was in foster care or probation, and then the juvenile court dismissed that dependency or wardship. So subsequent guardians are guardians who are named after the initial guardian was already appointed if the initial guardian is unable or unwilling to provide care for a child or youth. So you will hear terminology like alternate guardian, successor guardian, or co-guardian. And there are different processes depending on the circumstances, but in general, anytime a subsequent guardian is named or appointed through the juvenile court, they don't have to go through that whole 6 months of placement in an approved home requirement. And then they don't have to go through the resource family approval process. And all subsequent guardians should be receiving payment from the day they began providing 24-hour care to a child or youth once King Gap payments resume. So let's say the initial guardian was unable to care for the child anymore. It took a month or two for the case to go to juvenile court and get a new guardian appointed. There may be a little pause in payments for that month or two. But what this last bullet point is saying is that once the payments can resume, those payments should resume to day one of when this subsequent guardian was providing care to the child. So you should be receiving all payments retro back to the day that you were providing care to the child. Next slide. So I'm not going to go through each one of these, but essentially alternate or co-guardian fall under state King Gap. And this is when a different guardian needs to be appointed for the child or youth. And you'll see in statute and in regulations, sometimes the alternate co-guardian terminology is used interchangeably. But based on the circumstances, those statutes and regulations would apply to either the alternate or co-guardian. Successor guardians fall only under the federal King Gap program. And this is under those circumstances when a current guardian dies or becomes incapacitated. And in the initial King Gap agreement, a successor guardian was named. Then that means the federal King Gap can resume to the new guardian. However, in a lot of cases, the county and the guardian don't name a successor guardian. That doesn't mean they don't qualify for payments. That just means that you're going to revert to state King Gap as an alternate guardian. So if the new guardian does not meet the criteria for federal King Gap as a successor guardian, county would be paying state King Gap and not federal King Gap for the alternate guardian. Next slide. So non-related legal guardian are for non-related individuals caring for a child. So if a child is placed with an individual or a caregiver who is not related to them and they enter into permanency, if the child is not federally eligible, they wouldn't qualify for the King Gap program. However, the county would be issuing payments as a non-legal guardian. So the NRLG program allows for payments to a guardian who don't meet the King Gap criteria. So non-related legal guardians would receive AFDC funding under this NRLG program if they don't qualify for the federal King Gap program. And then those bullet points are kind of what I just mentioned, and then the definition of extended family members are in the third bullet. And this is also in our manual policies and procedures, which are CDSS's regulations. Next slide. So for the King Gap program, there is a requirement for the county to review the needs of the King Gap child and family no less than every 2 years. So usually every 2 years or so, you will receive a KG2 form, which is a redetermination to make sure that nothing has changed. The child is still living there. Everything is okay. None of the living situation has changed. When a caregiver or guardian receives this, they have to fill this out and send it back to the county within 14 days. Otherwise, you may notice that your payments have stopped. And if you don't, and it's usually because the caregiver or guardian didn't see this form and they didn't send it back. But it's just kind of confirming that, yes, the child still lives here. I'm still providing care and or support to this child. Please continue paying me my King Gap payment. So this is what that is. Even though this is required every 2 years, the relative guardian and the county can negotiate an adjustment to the payment more frequently than those 2 years and document it onto a new an amendment to the KingGap agreement if there are changes to the needs or circumstances of the family. So there is an opportunity for guardians to negotiate an adjustment to the payment if the needs, for example, if the needs of the child increase. So just wanted to point that out, that the rate that you're receiving is not set in stone. It's negotiable based on the needs of the child and relative. Next slide. This slide is regarding payment responsibility. So many times families will move to another county, may move to another state. This slide is speaking to the payment responsibility. So the county that had the court-ordered jurisdiction of the child or youth are always going to be responsible for paying the KingGap benefits regardless of where the child lives. So if you move from Sacramento County to Los Angeles County, you're not going to go tell Los Angeles County that they have to start paying the KingGap payments. If you move to Texas from California, Sacramento County will always be responsible for their payments. If there are any changes to the payments or payments need to be negotiated, you would reach out to Sacramento County, not to the county that you may currently reside in, or not the state that you currently reside in, but to Sacramento County, because that is the original court-ordered jurisdiction county of the child. So if a family moves from California from another state, then the county, our California counties are not responsible for payment. So that's the second bullet point. Any family moving to California, similar to our rules where the original county of jurisdiction has responsibility for payments, if a family moves to California from another state, that state is responsible for payments to that family. Next slide. So the beginning date of aid is the day after the dependency or worship is terminated. So if termination of dependency occurs on August 15th, KingGap payments will start August 16th. However, you may not see that payment immediately because as the case is transitioning from foster care to guardianship, there may be a little gap there, and a lot of counties issue their payments on certain days of the month. So let's say your guardianship started August 28th, and that county has already issued all their payments for September, then you may not get your payment till the following month after that. So maybe October. So we do get a lot of concerns from guardians who have missed a payment, but sometimes there may be a little gap in that payment that you received, but you will always be retro paid back to the date that the guardianship actually started, which is the day after dependency or worship was terminated. Next slide. So these are the circumstances under which KingGap payments would end if the guardianship no longer exists, if the guardianship was terminated, if the child, decided they don't want to live with the guardian and they don't want to do anything with the guardian is not providing any type of support to the child, then the KingGap payments will stop. If the child or youth doesn't meet age requirements, so for example, they reach 18 years old and they've already completed high school, then KingGap payments would terminate. If they're receiving KingGap, extended KingGap, then the payments would stop if the youth, let's say, had a job and decided they don't want to work anymore, they don't want to do anything. So if they don't meet any of that participation criteria, then the KingGap payments would also stop. So those are the circumstances when KingGap payments would be terminated. Next slide. This slide, I don't know if you can clearly see the screen. So I'm going to actually read a lot of this to you because I can't see it that well. So this slide is regarding suspension of payments. In our manual of policies and procedures in section 45, it talks about, provides a criteria for suspending KingGap payments. And this can happen if, like I mentioned earlier, if you don't fill out the KG2 form, that's the statement of facts supporting eligibility for KingGap. If you don't mail that back within 2 weeks of the date it was mailed, you may see a stop to your payments. The guardian is no longer providing supporting care to the child or non-minor former dependent. The payments may be suspended as you're trying to get another co-guardian or an alternate guardian appointed. Payments would be suspended. If you're a non-minor former dependent and you're no longer completed one of those extended KingGap requirements, the payments would be suspended pending whether or not you're going to enroll back into one of those activities. The second to last one is about a youth who is subsequently incarcerated and wardship established. So they committed a crime and then they ended up going under the purview of the probation department. The payments would be suspended because the child will still be eligible for KingGap payments if they return back to the care of the same relative guardian, all the eligibility conditions are met. And there's an ACL there listed that kind of speaks to that. But that would be another reason that payments for KingGap would be suspended. And anytime any of these reasons occur and then they no longer are existing, then those payments for KingGap can be resumed. Next slide. One thing I want to point out here, because this has happened many times, if one of the circumstances require the county to pause those payments, we always advise counties to suspend them instead of terminating those payments, because once you terminate those payments, they can't be reinstated. So you would have to start back from dependency to RFA approval to 6 months, and you would have to go through the whole process again. So you should always make sure if there's a pause in your payments for whatever reason that the county has suspended your payments versus terminating them, because again, they cannot be reinstated. And this is very different from foster care payments, where I know sometimes foster care payments stop and then 5 months later they can reinstate them and start paying foster care funding again. KingGap payments don't work that way. So once terminated, they cannot be reinstated. Next slide. I know I went really quickly over the KingGap requirements. If you have any questions, you can email us at caregiversforyouth@dss.ca.gov. If you have specific funding questions or funding situations that you have questions about, you would email our funding and eligibility unit at fc-kg eligibility@dss. Thank you, everyone. Oh, are there any questions? Do we have questions in the chat? Or are we doing them at the end?
We're going to go ahead and do the questions in the end, at the end. So okay. This is time right now that if you guys have any questions for Charm, please go ahead and put them in the Q&A section so we can address them. I'm telling you, she is an expert in this, and she's the one you want to talk to. So get those questions in, guys. Thank you, Charm.
Thank you so much, Salima. Thank you for having me, everyone.
We appreciate you. Next, we're going to have the caregiver perspective with Jennifer Rexroad from CAC, and she's going to be introducing Brenda Checkliness. Go ahead, Jennifer.
Thank you for joining us today. We have a special caregiver here to share a little bit about her journey in caring for her granddaughter, and also how she got connected to support and benefits and services that allowed her to to meet her granddaughter's needs. So I'm happy to introduce you to Brenda Check-Lennis.
Thank you, Jennifer. I'm very honored to be here. I'm very honored to be part of this wonderful group of ladies. Before I get started on the various state and federally funded resources that I learned about, I want to read just a little bit so you know where I come from. I am grandmother, caretaker, and guardian of a very sweet little 7-year-old girl, Bristol, who was not expected to live 24 hours. She just turned 7 years old. She's declared medically fragile, medically complex, and she's ever so alive, happy, healthy, as much as her little body will allow it to be, and she is so loved. I am proud of the life that my husband and I, Papa and Grandma, have provided for this little girl. I wrote some notes, so bear with me. She is home with family where she's supposed to be. I'm not going to lie, in any caregivers out there, be it foster, kin gap, whatever it might be, you know, especially with a medically fragile child, you're tired. You're tired, but I am blessed and honored to be part of her journey. And that's what this is all about. Keeping families together is what this journey is all about, what her life is all about. And honestly, none of this would have been possible if it wasn't for the Kin Gap program. Bristol's probably over a $4 million baby. There's no way that anybody could financially support this little girl or other children like her if it wasn't for this program. I'm blessed that all of her medical supplies that are delivered weekly are paid for. There's so many services, but getting back to when I started this, we first got Bristol when she was about 10 months old. That was the first time, and we were a resource family. And I came in this with blinders. I had no idea other than focusing on what her medical cares were. And through a friend of a friend, I learned of all these other services that are provided. And praise God. One of them is IHSS. Before we talk about that, Bristol has Medi-Cal Calviva. And there's so many services just in that aspect alone that is provided. Like I said, her medical, her hospital. There's hardly any out of pocket. I know going through the system versus going through probate court, you're not able to get what I've gotten. Sadly, you know, it is through a CPS case, but I'm glad that I've learned what I've learned and hoping to share with you. So one of your services you can get is in-home supportive services, or IHSS. What they do, and a lot of these, they're either funded by the state or federally funded. This helps you find respite care that will come to your house. They will first come out, and every county, you reach out to them. There's these organizations in various counties. You get with a worker, you explain your story, explain whatever the medical or mental issues might be. They come out, they do a home assessment. Not so much your home in general. They're assessing the child at issue. They're assessing what the cares are needed, what all that we provide. And don't try to be Wonder Woman or superhero. Let them know, I'm tired. I need help. And even though you think that at the beginning you don't, you do. Do not become neurotic like me. And let them know that you need help bathing. You know, after all the medical's done, I don't have time to give her a bath, or I've run out of time in the day to do this other things. And that's all part of the assessment. It's a scoring system, a rating system, and they will help you find persons that are certified that will come into your home. And it's an interview process because you'll be the boss, you'll be the employer, and you get to choose who's a good fit for your family, who's a good fit for your precious baby, and you hire this person. And IHSS, and it's the same as the waiver program, which is the home care based agency that I call a waiver program. They're pretty much the same. One is funded by state, one is funded by federal, if I'm saying it correctly. And that's the same process. With Bristol, because she is so involved, we call her VIP, she gets the allotted hours, the maximum of 300 hours of respite care per month. From IHSS, she gets the maximum of 283 hours. So there's a total of 583 hours of respite care that you can find somebody not only to come in to do medical, they can come in to clean your house. They can come in to help you grocery shop, that are errands for the child. Everything that has to do with the child, you're able to hire these individuals or fire them if it doesn't work out. The control is yours, and they're there. Sometimes it is hard to find someone, but they're there, and these hours are made available to you under special circumstances, such as myself. When we lived up in the mountains before relocating, there wasn't a lot of choices. So I'm able to pay myself IHSS income. Even though I'm her grandmother, I'm Kinship, I can still pay either the waiver respite hours or the IHSS respite hours. I can pay myself. It's not about any financial gain here. That's not why we do that. We do this out of love, compassion for these children who that's all they want is somebody to love them. When I collect that money, it helps me, say, hire a nanny or somebody to come and play with Bristol while I'm doing other things. It gives me some freedom for me, and it's not that I'm wanting to run off or whatever. You need it because there is no breaks, especially with the medically fragile children. You don't get time off. You don't get a lot of vacation time. Our shifts don't end at 8 o'clock. You need this help. And I never, ever want anybody to feel as lost as I did when I first started this process back in 2017. And I was completely lost. And I was misguided several times until I found some wonderful social workers. And I went through many, not by choice. It's just various steps along the way. There's Medi-Cal, which I've talked about that. We also qualify, which is state funded, for respite care through Maxim Home Health. I know they're in various counties. Again, you would just have to call them up. They actually reached out to me after one of Bristol's mini hospital stays, but they have an LVN or an RN that comes out to the house, again, depending on your needs, and it's usually for mental, medical, and that has been a big help. All I can say about that is make sure that when you do have your meet and greet with this individual, that she is a good fit for your family. We're on our second one, and so far everything's working out great. They also provide playtime with Bristol, and like one of the Maxim nurses even told me, if you want to go sit out in the backyard for 8 hours and do nothing, she goes, that's your prerogative. You don't have to be here when they're here. You have this life, and you have to, and this is easier said than done, take care of yourself, because without us being healthy, how can we take care of our little ones? The regional center, and that goes into another issue, but on the regional center, it's my understanding that when the court dependency is terminated, once I became KinGap, the regional centers now manage the case as far as assessing. The regional center is also a great group, and you'll have your own individual caseworker, social worker. If you need help with the individualized education plans, the IEPs with the school, they will go and they will represent you and help you go through that process. Again, you're constantly learning with KinGap or any type of fostering or anything. But like Charm Lee was saying, it is your responsibility as KinGap, being a guardian, that all the educational needs are met, that we're advocates, and we are very strong. I am a very strong advocate for Bristol in the medical arena and also her education. And Mama Bear comes out, and rightfully so, because this is her best life that we're trying to create here. But the regional center, for some who maybe have transportation issues and you can't, for whatever the reason, say you don't have a car, your engine blew up, they will provide transportation services to make sure that you get to these appointments. There's all these individuals. It doesn't hurt to ask any question, and I've asked many. And with IEP, we talked about that, and I've had really good luck so far. I've heard other people, but everybody has their own individual story. But it was very nice when my social worker from Alta Regional, when she came to the school, because there was things, that's not my area of expertise. And it was nice having someone come in that was educated with this. It had to do with Bristol, who has a central line that the school is to provide a nurse. And I didn't know these things. So she was there, very nice, very helpful. I can't complain of any of these resources that I've dealt with. Everybody has been very understanding, compassionate, and you know, giving you that pat on the back, or even the hug through the phone saying, hey, I'm here. If you need anything, please reach out. So, so with Bristol, she's a lot of work, but I am so happy to be part of her journey. And she's my granddaughter. There's nobody else that should be raising her. If my daughter is unable to do so, which she is, I am the next best person. And I'm so thankful for this organization, for the funding that's provided through the KinGap program. So that's what I wanted to share. And one other thing, if I may, your hosting county where jurisdiction was established, they will send out to you the various forms in the packet. Once the county dismissed the dependency on my granddaughter, then I became eligible. They sent me documentation to fill out, and they provided me with everything of the various forms I needed to complete so that I qualified for the KinGap program. And again, they're very helpful people. So that's what I wanted to say. And thank you very much.
Thank you so much, Brenda,
Thank you.
for encouraging our caregivers, and we certainly want caregivers who've stepped up to care for their family or friends or other children who find themselves in need of out-of-home care. We want them to connect with all the services and support that are available to caregivers and youth to ensure that youth have all their needs met. And definitely to make sure that caregivers aren't left feeling like they're stranded or alone and they're not really sure how to navigate systems. So there are all of these different programs in place. Sometimes it's a little bit confusing to navigate, and we certainly encourage you to reach out to other caregivers in your community. You could ask your social worker for a peer mentor or a resource family liaison or a caregiver support group or somebody that can walk with you as you navigate systems. California Alliance of Caregivers does have a weekly virtual facilitated support group called Coffee with Caregivers, and there are other support groups available both virtually and in person around the state. So definitely reach out if that's something you think you could benefit from, because there really are a lot of people out there that would be happy to help and really want to offer you support and encouragement. And California Alliance of Caregivers offers other support and trainings. You can send an email when you request your certificate at info@caregivers.org. And now I think we can open it up to questions. So I'll pass it back to you, Salima.
Thank you, Jennifer. And thank you, Brenda. We do have some people in the chat telling you, Brenda, thank you for your information and time. So we appreciate everything that you said. So yeah, we are going to go ahead and get into the Q&A section. We have quite a few here. Let's see. Will this PowerPoint be available on the CDS Caregiver Support website? Yes, the PowerPoint will be made available at the end of the webinar, and it will be made available via email to all of the attendees. Plus, you can go on our website, our caregivers website, webinar website, and also CAC website. Next question, is the caregiver's authorization affidavit or the written child care agreement actual forms that can be printed out and filled in, or is it just an informal letter type that the parent would write? So the caregiver's authorization affidavit is a printable form. It's actually going to be one of the resources in your resource sections that we're including in this PowerPoint. And the child care agreement is an agreement that is written between you and the parent specifically for whatever you guys agree upon that you would be willing to do and how long it will last. And this can be something that is notarized. What is AFDC-FC? So that is Aids to Families with Dependent Children in Foster Care. So instead of getting CalWorks, which is a different payment, it allows that caregiver to get the foster care rate like a resource family would receive. Yes, the webinar is being recorded. Mira wanted to know if the webinar was being recorded so they can send it to the families who couldn't make it to the meeting. We appreciate you sending these recordings out. Spread the word. Let your friends and family know that we do these webinars monthly. And at the end of this actual webinar, there will be a post survey and for you to put in information and topics, suggest things that you would like to learn about or hear. And in that, you can also say the frequency that you want. Is one a month enough? So let us know, reach out to us. Can a 16-year-old request that a guardianship be terminated? So in California, both children over the age of 12 and the parents of children in guardianships can ask the court to end the guardianships. However, they must be able to prove that doing so is in the best interest of the child in a guardianship. Guardianships can only be terminated through a court order. This is a court order. What public assistance or organization can support informal kinship families? Ileana, one of the things that you can use is our California Kinship Navigator. So you can go on that website. They will help you. With resources. They will help you find things that you need. You'll go in, and it's a website that will be included in here also. And you just type in the information, resources will pop up, or you can ask for someone to call you, and they usually get back to you within the same day. Charm, I have one for you from Miss Maria.
Hi.
So Maria wants to know what happens if the Kinship youth has wardship established, but is not removed from the caregiver's care. So does the caregiver continue receiving Kinship payments during the wardship?
Yes, if the child or youth is still in the care of the guardian, they would remain there. A lot of times when there is a probation case, they are incarcerated. And that's what that ACL 1122 is about, that the Braswell lawsuit. But in general, if the youth is still in the relative guardian's home, then Kinship payments would resume. I think what I was mentioning earlier was that if a youth becomes incarcerated and then eventually goes back to that relative guardian's home, then you can resume Kinship payments. But if the child is still in the home, then the payments would continue.
Thank you. I do have another one for you, Charm.
Okay.
So Michelle wants to know, what is better for child and caregiver, Kinship or regular legal guardianship? How do resources and support differ?
If so, Kinship, like I mentioned earlier, is not an optional funding program. So you can't choose between, oh yeah, well, I want Kinship funding, I want this and that. So if you, let's say you went to probate court and decided, I don't want to go through the foster care system, I'm going to go get probate guardianship, you wouldn't qualify for Kinship. You would actually have to go get CalWorks. CalWorks would be about, let's say, under $400. The Kinship payment would be equivalent to a foster care payment, and any other increases in rates based on the child's needs. So it's not one of those. It's not one of those things where you can pick and choose which funding source you're going to go to. Is what you're eligible for. But legal guardianships through probate court, obviously you're not going to get Kinship payments or foster care payments. So that is significantly lower than payments issued through the child welfare services or probation departments. However, I should mention, if you do go through probate court, but you're a non-relative, you can actually seek NRLG funding through the county child welfare services department. So if you're not related and you do get probate guardianship, you're eligible for AFDC funding, which is the aid to families with dependent children foster care funding. If you do have guardianship and you're a non-relative, because you wouldn't qualify for CalWorks, since CalWorks is only available to relatives of the child.
Okay. And so I did have an NRLG question. Vanessa wanted to know, if that funding comes from Title IV, does it mean that the child is still technically a foster child? And is the case still technically open? She has 3 parts, so I'll let you answer that part first, and then I'll tell you the other 2. You're muted, Charm.
Sorry about that. So NRLG funding, which is AFDC funding, is state funding. It's not 4E. It's not Title 4E. So if you recall what I talked about, non-relatives and children being non-federally eligible, they would revert to the AFDC funding under NRLG. That's literally you receiving AFDC funding. The funding under NRLG is not indicative of whether or not the child is in foster care or not. You would have to make sure that sometimes the counties or the court will order guardianship and say, however, we still have some concerns. We still want the care and custody of the child vested in the county. So if the county still has oversight of that case of that child, it's still considered a dependency foster care case. However, If the court says, well, I'm appointing Salima as the guardian of this child, and we're terminating dependency because we don't feel like we need any more oversight over this case, then there is no dependency and you would still be receiving AFDC funding. So the fact that you're receiving AFDC does not imply that it's a foster care case or not. It's what the court orders with that appointment of the guardian. Does that make sense?
It does to me. So,
Okay, perfect. Thank you.
and so I think you answered the other two parts of her question, which was, would they still qualify for programs and services that foster children got, and how they would get access. Also, Vanessa, you can use the Kinship Navigator, the California Kinship Navigator also, and they can help you to access services that the kids may need. I'm looking to see if I have any more for you. I think you had just said a legal word, like someone was still in the system. So Michelle is asking, do they still qualify for resources that foster get? Why or why not? And so, Michelle, that's something that you would have to contact your local county office or whomever you are working with to see what resources your youth could qualify for, because in the system may not mean foster care system. So you need to check into that, since that was very vague. I apologize. Can a parent cancel a caregiver authorization affidavit if the document does not require signature for the parent? Yes, the parent can cancel it at any time because they still hold the rights to their children. And who initiates the court order for termination of guardianship? It depends on what type of legal guardianship you have. So the parent can initiate it. The child, if they are over 12, can ask for it to be terminated. The guardian can initiate it. So it just really depends on what type you have and what it is. But remember, it is a court order, so it has to all go through the courts. Someone is asking if a kinship guardianship through probate is able to receive AFDCFC. Can you tackle that one, Charm?
Yes. Kinship guardianship through probate is not eligible for AFDC. Those are, well, depends what you mean by kinship. Kinship could mean relatives and non-relatives in California. If you're a relative, you would not be able to go get probate guardianship and also receive AFDC. If you're a non-relative, you can take your guardianship paperwork from probate court and take it to child welfare and potentially receive AFDC, but there are certain things that you have to agree to and be in compliance with. So for example, you don't just go there and ask for money. You're also gonna probably have to be part of a case plan. The social worker will come out to your home at least once every 6 months. There are certain things that you're required to participate in and comply with the county in order to receive that AFTC funding, because you have to remember that is foster care funds. But if you're related to the child by blood, and you went and got probate guardianship, you would not qualify for AFTC. You wouldn't be able to go to the county and say, oh, I got probate guardianship, can I get AFTC? You would have to apply for the CalWORKS non-needy fund.
Does funding remain the same as foster care payment under guardianship if the child is ISFC? Do you know that one?
Oh, are you? I'm sorry.
I'm sorry, Trump.
So if you were in dependency and then you established guardianship, dependency was terminated, you entered into, let's say, the KingGap program. Remember, I mentioned earlier that there are supplemental payment rates. I'm not familiar with ISFC, but I do know that there are specialized care, LOC, level of care rates that differ based on the needs of the child. That's something that you would have to discuss with the assigned social worker when you're receiving your foster care payment. So when you transition into guardianship, you should still be receiving the same payment amounts that you were receiving to be able to meet the needs of that child with any type of extra needs.
Okay. And you just answered the other two questions, so that works. I don't see any other new questions at this time. Donna has been so gracious enough to put in the CKN websites. So please look in the Q&A section for that Kinship Navigator website that I've been mentioning. All of that information is in there. It has been made available to all of you guys. And then, okay, Michelle just clarified what she was actually asking you. So let me restate this to you, Charm, and this will be our last question. She said, which is better for the child and caregiver? Non-relative, I think that's saying non-relative can get guardianship, or regular legal guardianship, which offers more support and resources. A friend who is a regular guardian seems to get more support than me as a KinGap receiver. And if the caregiver gets KinGap, can they get CalFresh, or does that count towards their income when having KinGap?
Thank you for the questions in the Q&A because I missed part of what you said.
They're the
KingGap
bottom ones.
is
So
not considered income. I just want to put that out there. There are some limitations to assets and stuff. So if the family itself needs to apply for other benefits, the KingGap payment should not have an impact on that. So let's say the family already received some type of financial or other type of assistance from the county. You having a foster child who you eventually got guardianship over should not impact what benefits you're receiving otherwise.
thank you. I appreciate your answers. Okay, let's go on to the next thing. We're going to end the Q&A with that. If someone has any other questions while we're ending the webinar with the last little follow-up stuff, feel free to put them in the Q&A. We still will respond, and we will send you guys an email with all of the question and answers once we send out the PowerPoint to you. Okay. Next slide, Jelena. Thank you. So these are going to be a lot of the webinar resource materials you guys are going to receive, and you're going to receive a lot. So all of these links, when you get the PowerPoint, you are able to click on them and they will all open up for you. And it tells you the copy of the PowerPoint, different facts, different websites for you to be able to access. And online services. The California Kinship Navigator is in there. Options, when I discussed with you, that's other than guardianship, and the different comparison of guardians. Next slide. There's also materials if you have if you need information because you're going through the juvenile court process. This information right here pertains directly to you. The next slide is for individuals who have gone through probate court. This information pertains directly to you. So the caregiver's authorization affidavit is in this one. A few of you have asked for that form. Next slide. And the information, the different codes and ACLs pertaining to KinGap that was included in Charm's PowerPoint that is on this page. So you'll be able to go in and read more about that if you need more information. Next slide. Once again, important information, guys. It's so much money out here still, caregivers. Some of you guys have not been able to get your monies because, you know, either your information is not up to date or we haven't been able to contact you, you've moved. So if you fostered youth between March 19, 2020 through June 15, 2021, you should have received a caregiver pandemic stipend. If you have not received it, you can request a replacement card, okay? So you want to contact Blackhawk's customer service. This is their phone number. They are available 24/7. When you contact them, you're going to give them your first name, your last name, and that address on file that you lived at between that time frame that you were eligible for. So if you have any questions, please don't hesitate to reach out to us here at the Foster Caregiver Policy and Support Unit. You can send us an email at cpayments@dss.ca.gov. And go ahead in that subject line, put that you're contacting us regarding your caregiver pandemic assistance card. Next slide. So we've been having these monthly caregiver support webinar series, guys, and we appreciate you joining. So here's all the information. That is our webinar website. You can go ahead and reach out to us. That is our information and our email. Go ahead to the next slide. Our next tentative date is going to be September 21st. And I know a few of you in the Q&A was talking about information for level of care and specialized increments and medically fragile children. Next month, we are going to be going all over everything level of care. And the link to register will be coming soon. Please remember to fill out your post survey. We appreciate you for joining us today, and we are going to go ahead and end the webinar now. Have a great day.